We are continuing to keep a close eye on the John Edwards corruption trial. The prosecution calling lots of witnesses to the stand over the past 3 weeks. But as they prepare to rest their case, prosecutors say they won't be calling on the woman at the center of it all, Rielle Hunter. So what's the strategy behind this? Our legal panel joins us now. Former federal prosecutor Doug Burns, also criminal defense attorney Chip Merlin. Doug, the prosecution decides they've done their case. A lot of people speculated that they didn't have enough to make the charges stick. They apparently think they do, and they don't need Rielle Hunter to help make that case.
Well, that's true, and I also think, John, that they see some potential downsides with Rielle Hunter. You know, she's sort of like that snake you look at and you got to be careful of. While theoretically she could help their case on some level, she could also backfire, and I think that's the calculus they're engaging in. As far as their view of their own case, my position is they think, the prosecutors, that they've improved their lot in this trial. I think the reason they feel that way is that the jury dynamic is bad when a jury views a defendant as somebody who's engaged in a pretty massive cover-up, has lied about what went on. The checks, after all, at issue were made out to a furniture design company, and all of those sort of indicia and badges of covering up kind of make these prosecutors feel as though they're in good shape. The other huge point, I think, which I saw yesterday, is I think the prosecutors think that once John Edwards' wife learned of the affair, any movement of money after that point is clearly tied towards the campaign and the election. So I think that's what they're staking.
Right, because he had been arguing, or his side has been arguing, that it was really just about trying to cover up the affair, keep his wife from learning about it, not the general public. Chip, what about it, though? She could still testify on behalf of the defense. Would that be a wise move?
Well, we don't know, and I don't think the defense knows either, because throughout this entire matter, everybody's been concerned about what Rielle Hunter is going to say. As a matter of fact, a lot of this hush money was because nobody knew exactly what she was going to say. They kept transporting her all over the country, as a matter of fact, to keep your enemies closer, I think was what the quote was at the trial. So I don't think the defense, it's possible they could. I actually kind of doubt it. I don't think she's a very material witness to this case.
And in your view, Doug, the prosecution, which, again, a lot of people thought had a pretty weak case at the beginning, seems to have turned a corner.
No, that's what I was saying, John. You know, you look at a trial like an empty swimming pool. I'm not trying to be funny, you know, and as you fill it up towards that reasonable doubt line. And I think that, you know, jurors also, they're very smart and they keep things very simple. And, you know, Chip knows this. In other words, we lawyers engage in, you know, very, very high amounts of minutia and thinking and strategizing. But jurors are like, wait a minute. Did he try to hide this? Did he try to cover it up? The answer is basically yes, from everything I described earlier. And then they say, did he do it just because of his wife, or was he doing it in connection with the campaign? And they keep things simple. And that's why I think they've improved their case.
Yeah, and Chip, Jennifer Palmieri, the former speechwriter, was apparently in tears on the witness stand yesterday, recounting a conversation that she had with the late ex-wife, Elizabeth Edwards. That can't be good for his case, just all of the sympathy directed toward Elizabeth.
Well, in front of the jury, obviously the sympathy part is not going to be in John Edwards' favor at all. An affair is bad. Paying a mistress to keep quiet, that's bad. Everybody knows that bad. But the prosecution has to prove that John Edwards violated the letter of the law. And in this particular case, the letter of the law is very technical federal election standards and laws that are very questionable if they've been broken. Does this qualify under the law, the giving of, quote, money to a mistress to keep her quiet, as a campaign donation or a campaign expense? And they're arguing, the lawyers for Edwards, that it doesn't as a matter of law. The law could have been written that way, and maybe this is bad, but he did not break the letter of the law and didn't do it willfully either.